Okay. All right. I was not planning on addressing the contact tracing, Christina. Not in this video. Certainly, in general, yes. While we're waiting for people to get on board, I can tell you as far as the contact tracing goes, it definitely violates Article 1, Section 11 of our Michigan State Constitution, as well as the Fourth Amendment of our United States Constitution. So that's just the beginning of the argument, but it's something for now. Okay. Oh boy, 6314. I am not sure what 6314 is. If somebody wants to get me, if it's still a bill, I'd like to see the most current version of the bill. If it has passed and it is now signed into law, I would appreciate seeing the most recent version be while it still had all the markup, where it showed things that were being, striked out or things that were being added. Once it becomes a law, then the text is all the same, and then it's hard to see. Okay. Oh, Jane, sorry to hear about that Facebook jail. Flower sitter, your doctor cannot do that to you. That is a violation of his or her oath and to do no harm. And it's also a violation of your constitutionally protected God-given liberties. But I'm not going to be able to get into that. Trump Girl 2020, when you hear what I'm going to say, you're going to understand why she has been getting away with all of this. And it's kind of ugly. So, all right, we got quite a few people on board now. We're over 200. That's a good start. So I'm going to go ahead and get started. For those of you who are just coming on board because it's you clicked a link or a friend said, hey, check this out. I am constitutional attorney Katherine Henry, and I'm the founder of the Restore Freedom Initiative, a constitutional amendment petition to stop all this crazy COVID madness and all the other government insanity we've been seeing for decades. And we'd love to have you on board and help us collect signatures for that. I'm also the owner of the Restore Freedom with Katherine Henry PC law firm, and I'm the one that's been filing briefs with the Court of Appeals and Michigan Supreme Court, and I did get the opportunity to argue against the governor's executive orders on September 9th in front of the Michigan Supreme Court. I will continue to keep up this fight in a variety of ways, but as you can probably tell, things are getting a bit complicated. So we have issues on our Second Amendment rights being directly attacked, as well as the separation of powers, by having a Secretary of State who seems to think that she can create laws about Election Day and violate our God-given freedoms. We also have the Michigan Director of the Department of Health and Human Services issuing these emergency orders that, number one, completely violate the state law he's claiming gives him the authority, and number two, violate the U.S. and Michigan constitutions. We also have courts that even when we win and they declare that things are being done unconstitutionally or illegally by these government officials, they're ignoring some of the big key aspects, such as we have freedom that we don't have to prove every single aspect of the way that we have. So it's with all of that in mind. Super talented today. Apparently decided to spill water at the beginning of this, so yay. I just want to make sure you know I'm human. So we're going to get right down to the brass tacks of things here. What I'm talking about today is specifically House Bill 6032. It was recently passed, approved by the governor on October 22nd. So 1 week ago today. Man, the week flies fast. It is, well, I won't jump to that. I'll take this in order. It's going to be hard. There's a lot to say about this thing. So this is now known as Public Act number 238 of 2020. And here's some interesting things. This one was actually introduced by mostly, if not all, Republican representatives. In fact, some of them I would have considered friends or, associates, colleagues, whatever you want to call it, people that I know of or have encountered or have worked with on a variety of things. Filler, Albert, Bran, Allor, Weber, Bellino, Stephen Johnson, Paquette, Alexander, Meerman, Slay, Kelly, Lauer, Marino, Lefebvre, Wozniak, Rendon, Markkinen, Maddock, Van Single, Bolin, Miller, Vaupel, Farrington, and Frederick. So some of these I don't know off the top of my head. I do believe Representative Brad Slay is the Holland area, and Julie Kelly is the 87th district, which would be Ionia County and Berry County. Tommy Bran, I believe his district is entirely within Kent County. I believe Stephen Johnson's district is entirely within Kent County. Let's see, Thomas Albert is the 86th district. That is Belding, the city of Ionia, the city of Lowell, Ada, Cascade, Caledonia, several townships all in between. Julie Alexander, I can't think of where her district is. I want to say it's over Port Huron way. Luke Meerman is the, are we 88th or 90th? I can't remember what House district I'm in these days. Well, it's either the 88th or the 90th. And anyway, he is Ottawa County. Let's see, Lauer, I want to say is, let's see, would that be Greenville and up? Tommy Brand, the owner of not all the Brand's restaurants. I'm going to be fair because Johnny is a good dude. The owners of the other ones I haven't had a problem with. Tommy Brand, since COVID-19, is really starting to tick me off. So yes, Tommy Brand is the owner of the one on Division, just south of 44th Street. But he does not own the one in Granville. He does not own the one in downtown on Leonard. Okay, so, Sergey, you are not going to like what I have to say on this. Bowl of Fave is on here. Markkinen, I believe, is from my very own hometown, Hancock, unless I'm mixing him up with somebody else. I was told he was a good, strong conservative. Don't think I've ever met him myself, but he's not going to want to meet me now. Matt Maddock, I want to say Oakland County. And let's see, Miller. I really hope this is not Representative Aaron Miller, but I don't know that there's more than one Miller in the House of Representatives. Aaron Miller is really good dude, so I get really sad when I see his name on things like this. The other ones I don't know off the top of my head where they're from. So just wanted to give you the complete listing of the individuals that introduced this bill. So what this is, they claim this is what it's called. This is an act to prohibit an employer from taking certain actions against an employee who does not report to work under certain circumstances related to COVID-19, to prohibit an employee from reporting to work under certain circumstances related to COVID-19, to prohibit discrimination and retaliation for engaging in certain activities, and to provide remedies. Well, so we're going to start with, well, first of all, I find it very interesting that it has section 1, it has a section 3, a section 5, a section 7, a section 9, 10, and 12. So not only does our legislature and our governor not know how to read the Constitution, they also don't know how to count sequentially. Yeah, the gloves are off on this one, guys. So, principal symptoms of COVID-19 is defined by an order of the director of MDHHS. So they're going to yield to his, wisdom in this whole situation. And in the event that he does not choose to define the principal symptoms of COVID-19, they define it here as one or more of the following symptoms: fever, shortness of breath, uncontrolled cough. Okay, so far we're talking about things that you get in the winter when you live in Michigan. Or two or more of these following symptoms. Baby dude, you got to have your feet off the desk, Emma. Abdominal pain, diarrhea. Diarrhea has nothing to do with COVID last I checked with the CDC, but our state legislature, they're just so smart. Loss of taste or smell, because that's so dangerous. Muscle aches, severe headache, sore throat, and vomiting. So what do all those things have to do? Well, I'm going to come back to that in a second. So if we skip section 2 that doesn't exist and we go on to section 3, you will see that it says an employer shall not discharge, discipline, or otherwise retaliate against an employee who essentially is complying with this law by not coming to work, which I'll explain in a minute, or who opposes a violation of this act. Okay, that sounds benign. Or 3, who opposes health violations related to COVID-19. Interesting. Health violations related to COVID-19. So we're going to jump on that for just a second. What exactly does that mean? Well, a health violation related to COVID-19, let's see, do they actually define that here? They do not define that here. So the fact that they're giving credence right in this statute to what the MDHHS director is doing leads me to believe that they are under the very erroneous assumption that the MDHHS director's orders under 333.2253 are lawful and constitutional. And so therefore, this leads me to believe that, and the effective date, which we'll talk about later on, that they're saying that any of the governor's executive orders, when they were in place, the Michigan Department of Health and Human Services directors, executive emergency orders, or the local health department orders, or any kind of other minutia, or any kind of other government entity that wants to forget that we live in the United States of America and we have a Michigan and United States Constitution. Any of those government regulations, if an employee says, for example, you are not requiring your employees and customers to wear masks, you're not requiring them to have their temperature taken and to have contact tracing methods used so their every whereabout is reported to the government, how dare you? In those situations where the business is actually protecting our God-given freedoms, what this is saying is that an employee who's off their dang rocker, they're allowed to go ahead and report them to the government. You know how our governor and then later our attorney general, Dana Nessel, have decided to try to strong arm people into reporting their neighbors and friends and businesses and employers who are not following the rules. Well, yeah, that's this kind of behavior. So go ahead and report your employer for not making you wear a mask, for not violating the rights of all of their customers and all of their employees. And even though they would be in the right, we're going to say here in this statute, if you as an employee are reporting your employer for violating one of these completely illegal or unethical or unconstitutional orders, or otherwise directives from the government related to COVID-19, they can't do a darn thing to you. In fact, if the employer tries to retaliate against you in any way, so say, for example, fire you because you are more interested in violating the rights of others than you are in working for their company, then the company is going to get in trouble. In fact, I'm going to jump down here. Section 7 says that the employee who's aggrieved, that poor employee, can sue the employer and will be awarded no less than $5,000. That is what's called statutory damages. Let's put this in context. When House Bill 5672 came out, and someone made me aware that our state legislature voted, I want to say 107 of the 110 voted in favor of House Bill 5672, which supposedly protected employees from being forced to be microchipped as a condition of employment. Well, the only damages, if the employer went ahead and tried to force you to be microchipped anyway, you were limited to actual damages. And I don't know where the bill sits. If it's, I think it's still pending with the Senate right now. I don't know if anything's been changed. So far, I haven't seen any proof of that. But the concept was you are limited to actual damages. So basically, if you win your trial and prove that the employer was forcing you to be microchipped as a human being, then all you could get was actual damages. And so you'd have to prove every single receipt of what you were out of pocket in order to get anything. Oh, and you get the attorney's fees, because obviously attorneys, should be getting all the money and everything. Clearly I have the wrong outlook on that, and that's why I'm living on donations. So by the way, if you like all the work that I've been doing, please go to restorefreedomkh.com and click on the donations tab and donate as little as $5 or as much as $5 million, whatever you would like to donate to funding this work. That would be the square button if you want to do it online. Otherwise, you can send a check, and I would appreciate that too. I have to do that plug, otherwise I don't pay my bills, right? So at any rate, you compare the 5672, where they were limiting people to actual damages, to this bill, where an employee who tattles on their employer for sticking up for the constitutional freedoms of the employees and of the customers, that employee gets no less than $5,000 just right out of the gate. Really? Wow. The legislature clearly has their priorities messed up on this one. So, I mentioned that the employer is not allowed to discharge or discipline or otherwise retaliate, right? Which was defined in the original version introduced into the House, but is for sure no longer defined. Yep, no longer defined in here, which means it could be a wide range of anything that they feel like qualifies as retaliation against an employee. So in here, an employee can and actually must stay home. When? All winter. If you think I'm being sarcastic, listen to this language. An employee who tests positive for COVID-19 or displays the principal symptoms of COVID-19 shall not report to work until all of the following conditions have been met. Very important words. That's why I'm emphasizing basically the whole sentence. Number one, what does report to work mean? What about individuals that are like my dad, who works from home? He works at his computer. Is he not allowed to go from his bedroom down the hallway into his office, sit in his own home, click the on button to his computer, and report to work? Because that's the way this law is written. Aside from that, they can't report to work until all of these conditions are met. Let's talk about what those conditions are. If the employee has a fever, 24 hours have to have passed since the fever has stopped without the use of fever-reducing medications. The second condition is, so we have the 24 hours after a fever, right? 10 days have passed since either of the following, whichever is later. The date the employee's symptoms first appeared, or the date the employee received the test that yielded a positive test for COVID-19, the later of those two. So you have the 24 hours plus the 10 days. So why even bother saying the 24 hours? That's just stupid. In addition to that, you have to make sure that the employee's principal symptoms of COVID-19 have improved. That could be complicated or problematic. I'm going to pick on my husband for a second. Poor guy isn't even here to defend himself. Hopefully he'll come in during this video. But let's get to some of those principal symptoms. So on the list of where you need 2 or more, let's look at, say, muscle aches and severe headache. my husband has been diagnosed with migraines, but his migraines are not the headache type of migraines. His migraines are the ocular, where it affects his vision. But he does sometimes just get really bad headaches that have nothing to do with the migraine. So there's no medical diagnosis tied to it. Also, my husband looks like he's only 22, but he's a lot older than that. In fact, we have a sophomore in college, if you can believe it or not. So sometimes getting a little bit older, his muscles ache, and he might not have a known medical condition other than human existence for why his muscles might ache. And yet, according to this, if he's happened to have one of those batches of time where he's getting those headaches and his muscles are sore because he's getting a little older, and we live in Michigan and it's winter, he would actually need to wait so he's excluded from work then during this whole time. He cannot, under this law, go to work and earn a living, and he cannot go back to work until 10 days have elapsed, and his symptoms have to improve. Well, assuming it's not COVID-19 or anything, that's actually deadly for someone like my husband, if he gets muscle aches and he gets, severe headaches, he might have that one day. He might even have it 2 days. That's very rare for him. But if he comes home early from one day because he just feels really sick, typically the next day he's going to feel better. And essentially then he has at least 10 days that he can't go to work. And then by the end of the 10th day, you know what? It's still winter in Michigan. He's still older than he used to be. And he might very well have another day where he's got muscle aches and a severe headache. Who knows? I've been trying to get him off of caffeine for years. Now, are they going to say that qualifies as a medical condition if the common sense is obvious that he's got a caffeine addiction, and if he doesn't drink his coffee or a Coke throughout the day, that he's going to get a severe headache? I don't know, because let me see here. A known medical condition. We'll see if they defined that. Nope, they didn't define that one either. Open to interpretation. I'm sure it'll be okay, though, because the MDHHS director, I'm sure, was given full permission to decide all these definitions for us. Isn't that great? So, man, this law sucks, and we're not even all the way through it. So, in addition to that, so you have to have the fever. If it's a fever, has to be gone without medications for at least 24 hours. But forget that, because you have to have at least 10 days since your symptoms appeared before you can come back, and your symptoms have to be improved. Again, who knows? It's Michigan winter. A lot of people I know just feel crappy all winter long. And maybe if we had a little bit of sunshine like they do on the beach of Florida, we'd feel a little bit better, but we don't. So then we go to section 2. So get this: an employee who has had close contact with an individual who either tests positive for COVID-19 or who displays the principal symptoms of COVID-19 shall not report to work until one of the following conditions are met. So seriously, if you encounter, what is the exact word here? Close contact. Is that defined? Means being within approximately 6 feet of an individual for 15 minutes or longer. Oh, wow. So, you mean being human and near other people. Okay, great. So, if you're at your church service, or you work at a place where it's just not feasible to be more than 6 feet away from every other human being, or who knows what, it's getting closer to the holidays. You're standing in line waiting for some groceries that have been flying off the shelves since March because everybody panics. And apparently in states like this, people are even prohibited from going to work. So yeah, we're going to have food shortages. Don't worry, the government's going to step in and fix it all for us, though. So here, if you spend 15 minutes within 6 feet of anyone who has a fever, shortness of breath, uncontrolled cough, abdominal pain, diarrhea, loss of taste or smell, muscle aches, severe headache, sore throat, or vomiting, then you are legally prohibited from going to work for at least 14 days since you had close contact with that person, or if the individual has a medical determination that they did not have COVID-19 at the time of the close contact. So, yeah, you're going to have to violate everybody's rights. And who's going to want to tell you whether they tested positive for COVID-19? I don't care what the situation is. I don't feel like I need to tell people all of my medical testing results. Guess that's up to you. But, and then how would you prove that? How are they going to enforce this? I bet they're going to say, oh, well, you know what? I think the Department of Health and Human Services will now get to make a form that a doctor's office will have to fill out. And maybe then another doctor's office, you'll have to have 2, 3, 4 appointments out of this whole deal with your doctor, because those are free, just to be able to go to work, whether you are sick or not. This is insanity. Not to mention, we have that part about how an employee gets to sue their employer for no less than $5,000. So here's a special nugget. Section 10, and that comes directly after Section 9. So that sounds like they know how to count, but directly before Section 12, because 11 doesn't matter, says that this act is effective retroactively to March 1st, 2020. Oh, and by the way, this act is ordered to take immediate effect. Okay, so what are the good things about this? Oh, there's none. Okay, so here we go on the law. So for anybody who might be new to me or who is just new to some of these constitutional concepts, it's super important that you realize our whole government is created to secure our blessings of liberty. God gave us our freedom. The government did not. They'd like to think that they do, but they did not give us those blessings of liberty. God gave them to us. And in our United States Constitution preamble, it says that we, the people of the United States, in order to, among other things, establish justice and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America. And that's in our preamble. Our state constitution preamble, I love it even better. I mean, I think it's phenomenal. We, the people of the state of Michigan, grateful to Almighty God for the blessings of freedom and earnestly desiring to secure these blessings undiminished to ourselves and our posterity, do hereby ordain and establish this Constitution. Again, that was the Michigan Constitution preamble. So I'd also like to point out, since we're on the topic of what God has given us, the First Amendment of the United States Constitution that says Congress shall make no law prohibiting the free exercise of religion. Likewise, our state constitution, Article 1, Section 4, says that every person shall be at liberty to worship God according to the dictates of his own conscience. So what's so important about that? Well, let's hold off just 1 second to have one more constitutional provision in here, because it's me. Article 8, Section 1 of our state constitution says religion, morality, and knowledge are necessary to good government and the happiness of mankind. So you take all of those provisions and you look at them and you say, well, something where they're impacting our liberties so drastically just feels wrong, right? It should feel wrong because do you know what God gave you aside from those freedoms? All the rest of them, the ones that are listed in the Constitution, the ones that are not listed in the Constitution. I want you to take a look at I always say Article 9, the Ninth Amendment to the United States Constitution, as well as to Article 1, Section 23 of the Michigan Constitution, which says that simply because we are enumerating or listing certain rights in these constitutions does not mean we can deny or disparage any of the other God-given freedoms in any other way. We have all of those freedoms. Those are guaranteed to us. Those are protected for us, not given to us in the Constitution. It says guaranteed to us because God already gave them to us. Well, how does this apply? Let's look at this in the context of, say, churches, pastors, ministers, ministry workers, Christian organizations. None of those are exempted from this. So they're saying that they can directly control who goes into a church to work or enable the worship events from taking place. They can control that. They can limit who can go in and out of a church. The government can. The legislature, the Republican-led legislature can do that. Interesting. I'm pretty sure all those constitutional provisions I listed so far, and we're just getting started, already tell us, no, you can't do that. So, what about the next concept? Government cannot impair our contracts. Okay, so we've kind of heard that, most of us, I think. What does that really mean? Well, that means the government cannot step into contracts between employers and employees like this. This doesn't even protect an employee. It punishes an employee. It claims to protect an employee. Does not. Contracts between one business and another business. So the supply chain, right? If you have, let's see, I have a friend who owns a restaurant, fabulous food, by the way, Florentine's, off of 28th Street in Granville. And I don't know if she still uses a company, but she had used a company that would come in and like wash their rugs and whatnot, their floor mats and things. I believe the same would hold true like for their napkins and their table settings, place settings, things like that. She would have a contract with the other companies to come and get their linens essentially and clean them and return them. And so she would have to pay them for that. That's a contract. Well, if 70% of your workforce is no longer able to show up and you're not allowed to replace them because that would be punishing the employees that can't go to work, I don't think she's going to need all those linens to be changed over and cleaned all the time because she's going to hardly be able to stay open. Same thing with businesses that have, uniforms that they hire or contract out to a company to take care of or clean or mend or whatever. What about businesses that, let's say a business who has shoveling, they do lawn mowing in the summer and spring. They do shoveling or plowing in the winter months. And so that you have a contract, you're a business owner, you own an office building, and it's a small mom and pop shop that you own, but you have this contract for somebody to come and plow your snow and everything. And the 4 employees that you have all fit in the definition of people that are not allowed to go to work. So you literally have no one there to do the work. You are not bringing in any money. How are you going to be able to pay the guy who's coming to plow your snow? You're not. I guess that doesn't matter to these legislators. I mean, we already knew it didn't matter to the governor. So what about businesses and their customers? How many small businesses are going to suffer and even have to close because their employees will be out and they will have literally no one there to complete the work. How many businesses do we have that are the micro businesses, right? That have less than 10 employees. You start telling people that if they have the common cold or flu or COVID during a Michigan winter, that they are not allowed to go to work for weeks. Who is going to be there to work at these facilities? So the interesting thing, we talked about all the different kinds of contracts or what this might entail. The United States Constitution is very clear on this. Article 1, Section 10, Clause 1 says, no state shall pass any law impairing the obligation of contracts. And guess what? Our state constitution, Article 1, Section 10 says, no law impairing the obligation of contracts shall be enacted. And yet we just heard how this very bill, or now public act, definitely and directly impairs contracts. So what is that, like strike number 5 in terms of constitutional provisions that our state legislators and our governor have decided they're going to violate all in one foul swoop? And by the way, this bill is not very long. 1 page, 2 pages, not even, you take out the header there, it's 2 pages long. In 2 pages, they've already violated, I don't know, how many have I said? 6, 7, 8 constitutional provisions? But we're not done. What about individual equal protection? The U.S. Constitution in the, I can't do Roman numerals today, 14th Amendment, Section 1, says that nor shall any state deny to any person within its jurisdiction the equal protection of the laws. Our state constitution, Article 1, Section 2, so very important. It's literally like the second full sentence of the first article of the entire state constitution. No person shall be denied the equal protection of the laws. Yet, those with, say, generally poor health or simply individuals who become more prone to suffer the ill effects of a typical Michigan winter are literally prohibited under this new law from earning an income. Gee, I don't think that screams equal protection under the law. I'm generally healthy. I generally do not have, the symptoms of COVID-19, as they've said. I generally like to do a lot of natural remedies. I go to my chiropractor, and I've worked with my family doctor on how to build up my immune system, how to live a generally healthier lifestyle. And because of that, I probably would not, if I worked for a company other than here, I probably would not have this problem. But there's a lot of people, a lot of Americans don't eat very healthy. They eat a lot of fast food. They have a lot of caffeine. They don't take all the right supplements and herbal remedies and things like that. Or even if they do, they just have underlying health conditions that really have nothing to do with COVID-19, but they are those kinds of conditions that just are exacerbated in the winter and then are making them more susceptible to typical Michigan winter crud. That's what this is, typical Michigan winter crud. So those individuals are definitely going to be impacted negatively by this. So what about due process, right? That's something that we hear a lot about. Sorry, it's getting really hot in my office. I'm just going to open the door. Okay. So, in the United States Constitution, the Fifth Amendment, you guys have all heard this, but it's relevant, so I'm going to read it to you now. No person shall be deprived of life, liberty, or property without due process of law. Likewise, in the 14th Amendment, it says that nor shall any state deprive any person of life, liberty, or property without due process of law. It was so important to the framers, to the people that are there drafting it, to the people that are there voting these provisions in. It was so important to us as a country that we literally have this same exact language in there twice. You can't deny someone life, liberty, or property without due process of law. That does not mean whatever the government wants to do is going to be good enough and rubber stamped. No, these are God given liberties that the government can't just take away, and yet they think they can, clearly. But here in the state of Michigan, we wanted to make sure, beyond those two constitutional provisions in the United States Constitution, that we would be equally protected under the Michigan State Constitution. Article 1, Section 17 says, "No person shall be deprived of life, liberty, or property without due process of law." So what does this look like? Okay, I'm complaining about due process. How does that really impact us? Well, let's look at from the business's perspective. They have absolutely no say on how many sick days an employee, or for that matter, all of their employees, may take, and may make absolutely no remedial measures to alleviate the problems of chronic absence, all without any kind of day in court at all. So let's say you have an employee that just doesn't feel like going to work. Well, they can say they have symptoms of COVID-19, and then they'll be prohibited from going to work. What about so what about testing, right? Because then you can force your employee to get tested. Well, right here it talks about after displaying the principal symptoms of COVID-19, if the employee fails to make reasonable efforts to schedule a COVID-19 test within 3 days after receiving a request from their employer to get tested for COVID-19, that's when you start to have some problems. So how many days does that really take? So it's not the day that you say, oh, I've got symptoms of COVID, I got to go. It's your employer then has to jump through the hoops of making that formal request for you to do so. And then you have 3 days. And even then, it's just you have to make reasonable efforts to schedule the test. It doesn't mean that's when you go in for the test. Hey, Mike, you want to come in for this one? It's a good one. So, okay, where is I going with this? At any rate, so again, we are leaving employers all without recourse because they can literally do nothing. If they try to get new employees to fill those positions, if they try to give other employees hours that typically belong to somebody else, thank you, Tom. If they give other employees hours that typically belong to the sick employee, that would be deemed as an otherwise retaliatory measure. You can't discharge, you can't discipline, you can't otherwise retaliate against these employees. So you can't fire people that are literally going to be gone all winter long, and you don't have a way to fill those hours with work and be able to do your job as a company. Great. So that's definitely an issue where they have no due process afforded to them. Also for a business, if an employee, quote, reports health violations related to COVID-19, end quote, that's out of the part I read to you earlier here in this bill, to the health department, such as not requiring employees or customers to wear masks, not forcefully taking the temperature of their employees or customers, not violating their employees or customers' rights against unreasonable searches and seizures with contact tracing. Thank you very much. That's pounds. I don't know what that converts to, but thank you. I appreciate that. The business is not allowed to fire the employee or even so much as put a disciplinary note in this file. So let's break this down. Let's unpack this. So the government is strong-arming businesses to violate the individual liberties of Michigan employees and customers. And when that didn't work on its own, when the governor's executive orders didn't work on its own, the MDHHS emergency orders added civil punishments, $1,000 for each occurrence, and business licensing penalties, which we're going to have to get into at some other time because that's a whole nother story. Yeah, I've got a bunch of little notes right here all about the constitutional provisions that are being violated on that alone. Anyway, and when businesses still refused to violate the rights of their employees and their customers, hey, Mike, can you open that door a little bit? I just done that. It's a little too hot in here. The legislature passed this law to prohibit businesses from firing employees who fight to go along with the liberty-crushing government mandates. So I'm going to repeat that last part again. So that when the businesses still didn't bow down to the governor's executive orders or to the MDHHS emergency orders, some businesses are still trying to protect our rights. The legislature passed this law to prohibit them from firing employees when those employees are fighting to go along with this liberty-crushing government mandate garbage. And if a business does fire or discipline an employee for doing that, the legislature said the employee can sue and get no less than $5,000 from their employers. Section 7 of this new law, not the 7th section. Keep in mind, they don't know how to count. So there is no Section 2, and there is no Section 4, and there is no Section 6. It's in Section 7, though. So what about individuals? Well, need another drink of my Diet Root Beer Zevia. So, individuals have an undisputed property interest in their ability to earn a living. I could give you a bunch of case law on that. Thank you, Red Ring fan. I could give you a bunch of case law on that, but quite frankly, 171926, Kevin, can you please hold on that question? I will definitely answer that. That is a very good question, but let me answer this in context here first. And thank you, the Yard Dogs. I appreciate that as well. So, okay, so we're going to put this into context, okay? Individuals have a property interest in an ability to earn a living. So what's going on here? Well, you might not believe my ability to give you facts and figures from, the medicine or the science behind this all. I have reached out to, oh shoot, can you remind me to reach out to the doctor from that first episode? We have four medical professionals that I've reached out to answer some very important questions about COVID-19, medically or scientifically speaking. And I already have researched and I know the answers to these questions, but I want to make sure that I'm not blindly going into something, that I am, Mike, can you answer the door, please? That I am, sorry, too many distractions here. That I'm giving you the most clear information, okay? And so I haven't had a chance to get all that together for you yet. I'm working on it. In fact, I think 2 of them have already gotten back to me. And I just need to compile all that, and all of that will actually be available on my website, restorefreedomkh.com/resources. There will be information right on there. And it'll be a lot, and I'll try to have like a summarized version or an easy way to glance through it, categorized, whatever. But I will give you information from expert epidemiologists and immunologists, from doctors of chiropractic, from physician's assistant who own their own businesses, PPE experts who are veterans and have worked with masks and these kinds of things for their entire careers. All kinds of medical professionals. We're going to bring their medical opinions and their scientific opinions into this discussion for you. But for now, because I didn't have time to collect all of that while this nasty bill was being passed, there is a link at mayoclinic.org. You guys have heard of the Mayo Clinic. If you go to their section of diseases and conditions, go for the common cold, or search for the common cold, symptoms and causes, okay? I last went to that website just today. They say that the common cold is a viral infection, so far sounds familiar, right? Of your nose and throat, upper respiratory tract. It's usually harmless, although it might not feel that way. Sounds like COVID, usually harmless, although it might not feel that way to some. Many types of viruses can actually cause the common cold. Children younger than 6 are at greatest risk of colds, but healthy adults can also expect to have 2 or 3 colds annually. And if you go to their full list of symptoms, oh, let me see if I can get that. Let's see. Okay, typical symptoms: runny or stuffy nose, sore throat, cough, congestion, body aches, headache, sneezing, fever, generally feeling unwell. Did I say fever? Shortness of breath. These are the more serious symptoms for adults. Shortness of breath, wheezing, severe sore throat, headache, or sinus pain. And in children, severe symptoms are fevers of over 100 degrees or 100.4. Symptoms that worsen or fail to improve. Severe symptoms such as headache or cough, wheezing, ear pain, extreme fussiness, unusual drowsiness, lack of appetite. That's the common cold, guys. That's the common cold. Did you listen to all those symptoms? Because I read most of those symptoms earlier to you when I was describing how they're defining COVID principal symptoms. Also, if you go to the CDC itself, right? So the next time I get one of our state reps that says, oh, well, her sources are terrible, you should check her and her credentials and all of her sources. Guess what? These come right from the government. cdc.gov/flu/symptoms/flu versus COVID-19. Went there today to check it out. What they say on there, again, this is the CDC. Because some of the symptoms of flu and COVID-19 are similar, it may be hard to tell the difference between them based on symptoms alone. And testing may be needed to confirm a diagnosis. So the symptoms are largely the same between the flu and COVID. And so you'd need a test to confirm whether it's one and not the other. Right. Okay. But it's all based on symptoms that were violating people's rights and prohibiting them from going to work. Great. Flu and COVID-19 share many characteristics, but there are some key differences between the two. This is word for word from the CDC's website as of today. Similarities. Both COVID-19 and flu can have varying degrees of signs and symptoms, ranging from no symptoms, asymptomatic, to severe symptoms. This is both COVID-19 and the flu. Common symptoms that COVID-19 and the flu share include fever or feeling feverish or having chills, cough, shortness of breath or difficulty breathing, fatigue or tiredness, sore throat, runny or stuffy nose, muscle pain, or body aches, headache. Some people may have vomiting and diarrhea, though this is more common in children than adults. Okay, so wait a second. If you look at the list that our state legislature gave us, fever, shortness of breath, cough, abdominal pain, diarrhea, muscle ache, severe headache, sore throat, vomiting. The only one that's not listed with what both the flu and COVID have is loss of taste or smell. And boy, is that a dangerous thing to have happen to you. Man, I might actually chew a piece of cinnamon gum or eat something with coconut on it. The differences. This is what the CDC says the differences are in symptoms between COVID-19 and the flu. Flu viruses can cause mild to severe illnesses, including common signs and symptoms listed above. Okay. COVID-19 seems to cause more serious illnesses in some people. Yeah, that's very misleading because if you continue with me, you'll hear how the CDC says the flu actually causes more serious illnesses in some people. But we'll continue. Other signs and symptoms of COVID-19, different from the flu, may include change in or loss of taste or smell. Literally, that is the only thing the CDC says is a different symptom of COVID-19. Yet, if you have the symptoms of COVID-19, which are the same as the flu, you can't go to work. But we've never outlawed the flu before. Oh boy. So, how long it takes for symptoms to appear? I'm going through all this because guess what? You know of that one person who might even be sitting next to you who's arguing and nitpicking and going, well, but COVID-19 is more dangerous. It's because of this and this and this. No, here's your facts and figures from the CDC itself as of today. Both COVID-19 and the flu, for both COVID-19 and the flu, one or more days can pass between a person becoming infected and when he or she starts to experience illness symptoms. That's what it says. Well, what about how long someone can spread the virus? Well, similarities. The CDC says for both COVID-19 and the flu, it's possible to spread the virus for at least 1 day before experiencing any symptoms. So what is the difference? You don't show symptoms you show symptoms later on, allegedly, for COVID than you do the flu. But what they're saying is it's possible to spread the virus for at least 1 day before experiencing any symptoms. So does it really matter how long it takes for those symptoms to develop? No, because you're not going to know or exhibit symptoms of COVID-19 until possibly a little bit later, but you're still only contagious for the exact same amount of time as the flu. Well, differences. Okay, so this is where it's going to get really good and tell us how dangerous COVID is, right? If a person has COVID-19, they may be contagious for a longer period of time than if they had the flu. Most people with the flu are contagious for about 1 day before they show symptoms. Older children and adults with flu appear to be most contagious during the initial 3 to 4 days of their illness, but may remain contagious for about 7 days. Infants and people with weakened immune systems can be contagious for even longer. So unhealthy people are contagious for more than a week, whereas the rest of us are contagious for a week with the flu. So then they talk about COVID-19. How long someone can spread the virus that causes COVID-19 is still under investigation. So in other words, they don't know anything on that point. Great. I'm so glad we're living out of fear because that's how God made us, right? To be fearful. Pretty sure it says it in 2 Timothy. It's possible for people to spread the virus for about, now it says for about 2 days. It just said they're both contagious for 1 day prior to experiencing any symptoms. And now on the same page of the CDC, it says for 2 days before experiencing signs or symptoms and remain contagious for at least 10 days after the signs or symptoms first appeared. So again, it's possible that you can be contagious with COVID-19 for, say, 10 days. But if you actually read the wording that I just said to you about the flu, it's possible that you can be contagious with the flu for 10 days because an average person, a healthy person, is contagious for 7 days, whereas someone who is immunocompromised or a child or something of that nature is contagious for longer than that. Well, it's not a stretch to go from 7 to 10 days now, is it? So it's the same amount of time. If someone is asymptomatic or their symptoms go away, it's possible they remain contagious for at least 10 days after testing positive for COVID-19. Literally, the wording is, it's possible. Yeah, it's possible. It's possible that would happen with the flu and the common cold. That's part of life. How it spreads. Again, the CDC tells us both COVID-19 and the flu can spread from person to person between people who are in close contact with one another within about 6 feet. Both are spread mainly by droplets made when people with the illness, COVID-19 or flu, cough, sneeze, or talk. These droplets can land in the mouths or noses of people who are nearby and possibly be inhaled into the lungs. So don't spit into somebody else's mouth, is what they're saying. It may be possible that a person can get infected by physical human contact, shaking hands, or by touching a surface or object that has the virus on it, and then touching his or her own mouth, nose, or possibly their eyes. Both the flu virus, sorry guys, there we go. Both the flu virus and the virus that causes COVID-19 may be spread to others by people before they begin to show symptoms, with very mild symptoms, or who never develop symptoms. All of that about how it spreads is the same between COVID-19 and the flu. The same. So the symptoms are the same, and it spreads the same, and the length of time you're contagious is the same. What about people at high risk for severe illness, right? Because COVID-19 is so deadly. That's what they're telling us. Well, similarities. Both COVID-19 and flu illness, according to the CDC as of today, can result in severe illness and complications. Those at highest risk include older adults, people with certain underlying medical conditions, and pregnant people. Those are the ones at risk for COVID-19 and flu severe complications. Not children, not average age healthy adults, just the 3 that are listed. Differences: the risk of complications for healthy children. This is important. According to the CDC as of today, the risk of complications for healthy children is higher in the flu or for the flu compared to COVID-19. However, infants and children with underlying medical conditions are at increased risk for both the flu and COVID-19. So for a child, if you are a healthy child, it's far more deadly for you to get the flu than it is COVID-19. If you are a child who is sick or is otherwise immunocompromised, it is equally as dangerous for you to get the flu as it is COVID-19. So it says flu. Young children are at higher risk from severe illness from flu than COVID-19. This is on the CDC's website today. COVID-19, it says school-aged children infected with COVID-19 are at a higher risk of MIS-C, a rare but severe complication of COVID-19. So they had to say something bad about COVID-19, right? Because if it was all bad about the flu, and when it relates to children, then, well, game's over, right? It's a stretch, and if you want to know how rare, well, hopefully one of my medical professionals has that cited and described down to the exact 100th of a percentage, because you're going to be shocked. Complications. This is on the CDC's website as of today. Both COVID-19 and flu can result in complications, including pneumonia, respiratory failure, acute respiratory distress syndrome, fluid in the lungs, sepsis, cardiac injury, heart attacks, stroke, multiple organ failure, respiratory failure, kidney failure, shock, worsening of chronic medical conditions involving the lungs, heart, nervous system, or diabetes, inflammation of the heart, brain, or muscle tissues, secondary bacterial infections, infections that occur in people who have already been infected with the flu or COVID-19. Those are the similarities between the flu and COVID-19. Now the differences: the CDC says the flu, most people who get the flu will recover in a few days to less than 2 weeks, but some people will develop those complications. Some of these complications are listed above. So what they're saying is there's actually more deadly or serious complications with the flu than the list I just read to you. For COVID-19, there's only 2 additional complications with COVID-19. Blood clots in the veins and arteries of the lungs, heart, legs, or brain, and this MIS-C, which is extremely rare in children. It's only in children, and in children it is exceedingly rare. Otherwise, there are more adverse complications, serious complications with having the flu than there is with COVID-19. So this law literally shuts down our state for the duration of the flu and common cold season. There's no other way to look at it. If you encounter someone who has any flu or cold symptoms, as talked about by the CDC, or even an outside organization like the respected Mayo Clinic, you cannot go to work for weeks, for at least 10 days. And that's if you have it. Go figure the common sense on this one. But if somebody else has a sniffly nose or a sore throat, then you can't go to work for 14 days. Oh, good question on that, Sergey. I'm not talking about the petition right now. Mike, can you write down Sergey's question so I can come back to it, please? Okay, so sorry, I'm frustrated at what some of the news is reporting that you guys are talking about. So, all of the employees required to stay home under this law are denied any kind of hearing or court proceeding, no day in court, before they're being stripped of their right to life, liberty, and property. Specifically in this instance, liberty and property. They're stopped from going to work. They're stopped from earning a living all cold season long. They didn't think this one through, did they? Cruel and unusual punishment. Our United States Constitution in the 8th Amendment says that cruel and unusual punishments shall not be inflicted. Article 1, Section 16 of our state constitution says that cruel or unusual punishment shall not be inflicted. How is it not cruel and unusual punishment to prohibit an employee from working for weeks at a time because they have the common cold or the flu or COVID? To put it into context with those who claim, take pieces of the Constitution out of context, Article 4, Section 51 is the thing that the governor's been trying to hang her hat on, right? Article 4 is legislative powers, but we won't go there because she doesn't know the difference between the executive branch and the legislative branch. But it does say in there, the legislature shall pass suitable laws for the protection and promotion of the public health. Suitable laws necessarily mean they have to be respectful of all constitutional provisions of our liberties and all constitutional limitations on government action. It's not suitable to create a law that gives the government more power. It's not suitable to create a law that infringes upon our constitutionally protected God-given liberties. And if you want to know where it talks about health in the United States Constitution, that would be nowhere. The word health appears nowhere in the United States Constitution. And the word health appears 4 times total in the Michigan Constitution. One of them is not really in the context of public health. The other 3 are dealing with natural resources, the ability for the state to own property, like to have parks or things like that help with our mental health, or to own state hospitals to, assist with public health. And again, this provision I just read right here, to make suitable laws regarding our public health. So none of those give them permission to do all this garbage. What about general welfare of the people? Couldn't it be argued that it's needed for the general welfare of the people? No, I I went into detail on that on a couple of other videos, 3 or 4 actually. In the United States Constitution, the word welfare only appears twice, once in the preamble, and it's talking about promoting the general welfare, not making regulations upon the people. And the second time is it's talking about providing for, paying for the general, the common defense and general welfare. The entire provision is talking about, I want to say it's Article 1, Section 8 of our US Constitution. It's talking about being able to pay our bills, to be able to have a military and infrastructure and other things that would be needed, roads and things where we need our general welfare is affected by that, and they can raise taxes to be able to pay for those kinds of things. It doesn't say that they can require masks and contact tracing and other garbage. In the Michigan Constitution, the word welfare only appears 3 times. Once it's talking about atomic energy, not relevant here. Once again, talking about natural resources, and where it is mentioned in Article 4, Section 51 that, let's see, how is that wording? Article 4, Section 51 says the public health and general welfare of the people of the state are hereby declared to be matters of primary public concern. The legislature shall pass suitable laws for the protection and promotion of the public health. So the legislature, excuse me, not the legislature, the people of the state of Michigan, by the Constitution, came out and said public health, general welfare, super important, but specifically did not allow the legislature to make laws about the general welfare, only public health. Both are important, but the legislature can only make laws about public health. Safety, it's only written once in the US Constitution. So this whole concept that this is to keep us safe, it's a load of garbage. I mean, I just went through even what the CDC is saying about this. It's only meant, the word safety is only mentioned once in the Constitution, US Constitution. And that's about the writ of habeas corpus shall not be suspended unless in times of war or rebellion when the public safety might require it. It has nothing to do with requiring us to wear masks or use contact tracing methods or prohibit us from going to work if we have the symptoms of COVID-19. No. The Michigan Constitution uses the word safety 6 times. Only 3 of them are in relation to public safety types of scenarios. The first one is the habeas corpus, same kind of wording that's used in the US Constitution, so that's not applicable to masks. Again, that phrase or provision about natural resources, and again, as we saw with health, the provision that they are allowed to own property for the general public safety, like have police stations and sheriff's departments and things like that. So if you want that background, there's no provision in there that allows for the wearing of masks at all. So what about a bill of attainder? I'd love to have this, be able to give this as a speech in a crowd and be able to ask how many people know what a bill of attainder is. I would love to see. In fact, I'm going to wait just a few seconds to see if anybody jumps on and says, I do know what that is. Nope. Nope. I don't. All right. So here is what it is. All right, guys. That's awesome. Thank you. Honestly, I didn't know what it meant either. I didn't even realize I didn't know what it meant. I've read it all these years in the Constitution, and it's just one of those things that you're reading along and you're reading for the context of things that apply to you. And I didn't realize I didn't know what it meant. It essentially means being punished without a trial. Well, we've already kind of touched on some of those concepts earlier, but if we look at Article 1, Section 9, Clause 3 of the United States Constitution, it says, no bill of attainder shall be passed. So what specifically is a bill of attainder? Well, to make it easy, I just grabbed what Black's Law Dictionary says, okay? I'm not going to get all complicated about it, but it is a special legislative act that imposes a death sentence on a person without a trial, or a special legislative act prescribing punishment without a trial for a specific person or group. We just talked about there is a specific group of people that are being singled out here because they just get the typical Michigan winter crud every year, and they're not going to have a doctor's note that says it's not COVID-19. That group of people alone are being singled out and punished without a trial. How about all the small business owners that just can keep enough staff on the books to get the job done? And then when they are prohibited from coming to work or even faking that they have, the symptoms of COVID-19 and they don't go to work, then all of a sudden the business is not able to be able to conduct business as usual. They're going to be harder hit than Walmart or Meijer or Best Buy or Amazon, right? They are going to be impacted all without a trial. They are going to be punished. And it says so right here. Again, for those of you tuning in that didn't quite see the full description here, we are talking about House Bill 6032 that has recently been signed into state law by the governor last Thursday, a week ago today. It is now Public Act 238 of 2020. So what else? We have that bill of attainder scenario. Well, we also have Article 1, Section 10, Clause 1, that says no state shall pass any bill of attainder. Again, one of those provisions that is so important, they said, we have it in here once, but it's so important. Sorry, guys, I have something that's trying to go into my contact here. We have it in the Constitution, the U.S. Constitution once, but this is so important. We want to put it in there a second time and specifically prohibit the states from trying to pull any of this garbage, right? Because this is before we have the later amendments that spell out, by the way, all these restrictions on Congress also apply to the states, right? So, well, in addition to that, our state constitution, Article 1, Section 10, says that no bill of attainder shall be enacted. Yet we are seeing these specific groups punished without a trial. They don't even get a day in court at all on these issues, unless they are being dragged into court to be punished by an employee who was fired or let go or punished in some way because they reported a health violation related to COVID-19. Well, what about ex post facto? Anybody know what ex post facto means? I'm going to see if anybody pops on real quick and says, oh, I know what that means. We got a bunch of no's so far. Okay. Yeah. Okay. There you go. After the fact. It means after the fact. So in the Michigan Constitution, the United States Constitution, Article 1, Section 9, Clause 3, no ex post facto law shall be passed. Article 1, Section 10, Clause 1, no state shall pass any ex post facto law. So important, they put it in there twice. The framers put this one in there twice because you can't pass a law and make something illegal or take away somebody's rights retroactively. That's insane. Again, our state constitution, Article 1, Section 10, no ex post facto law shall be enacted. So 3 constitutional provisions that say, hello, this is not okay. You cannot change the law and make something illegal or change something up that is retroactive to the detriment of any of the people. Well, Section 10 of this lovely Public Act says this act is effective retroactive to March 1st, 2020. March 1st, that is before there was ever a declaration of state of emergency in the state of Michigan or in the United States. But it's retroactive to that point. It is ex post facto. It clearly violates our state and federal constitution in at least 3 provisions just on that point alone. And yet, in this essentially 2-page bill, none of the legislators, none of the staffers, the governor, nobody could read that. Nobody could figure that out. Oh, and by the way, in order to have a law have immediate effect, it has to pass both houses, the Senate and the House of Representatives, by a 2/3 majority. Guess what? It says this act is ordered to take immediate effect. Fantabulous, isn't it? So what does all this mean? Well, I think right now I'm going to pause to tell you 101 state representatives voted yes on this bill. 0 voted no, and 8 did not vote on this. 101 with 0 voting no on this bill, this constitutional atrocity. In the Senate, 37 voted yes, and especially with giving it immediate effect. 0 voted no, with 1 senator not voting at all. So in both the House and Senate, not a single senator chose to stand up, or single legislator between all of these individuals could stand up and say, nope, this is not constitutional. I cannot be a part of this. Not a single one. Apparently, they don't know how to read the Constitution. Here's the deal, though. Regardless of whether they can read the Constitution, regardless of whether they like the Constitution or not, is irrelevant. What is relevant? Well, Article 6, Clause 2 of the United States Constitution declares that this Constitution shall be the supreme law of the land, and the judges in every state shall be bound thereby. Anything in the Constitution or laws of the state to the contrary, in any state, to the contrary notwithstanding. So you can't have a state statute that violates the U.S. Constitution. That's what that says, period. I don't care who you are. I don't care if you were elected or appointed, if you have $1 million, if you have $5. If you are serving in a government office, you should know that by now. And quite frankly, all of us as Americans need to know that. Article 6, Clause 3. The senators and representatives and the members of the several state legislatures and all executive and judicial officers, both of the United States and of the several states, shall be bound by oath or affirmation to support this Constitution. You have to take an oath of office under the U.S. Constitution to support the U.S. Constitution. What's even more is our state constitution, Article 11, Section 1, says that all officers, legislative, executive, and judicial, before entering upon the duties of the respective offices, shall take and subscribe the following oath or affirmation. I do solemnly swear or affirm that I will support the Constitution of the United States and the Constitution of this state. And it continues by saying you can take no other oath or affirmation in order to have that role in our government. But it's not just those people who are appointed or who are elected to public office. So far, we know that the governor, the attorney general, the secretary of state, the Michigan Department of Health and Human Services director, the all of our local county board officers and our local county clerks and register of deeds and sheriffs and everything else. We already know that those are elected or appointed positions that are covered by this. What about the person who's just in a clerical position or in a janitorial position with the government, with state government, with local government? What about that individual? What about a local school bus driver or a crossing guard or the lunch lady? MCL, which is state law, MCL 15.151 says that all persons employed by the state of Michigan or any government agency thereof, and all persons in the service of the state or any governmental agency shall, as a condition of their employment, take and subscribe to the oath or affirmation required of members of the legislature and other public officers, such as we just read in Article 11, Section 1 of the state constitution. Every single government employee, not just officer. So if you are a staffer for, say, the 86th District House of Representatives, and you write a constituent and say that we have to follow the MDHHS orders and that you're writing bills like this because it's to keep us safe and that we're working with the governor, and that's what's important here, and how the legislature voting to squash our liberties is what's giving the people a voice in this, you are on the hook. You individually are breaking your oath of office. It does not matter if you get a small paycheck or a big paycheck. It does not matter if you've worked there for 1 week or 30 years. You have the same oath to uphold the US and Michigan constitutions. It doesn't matter if you remember taking that oath of office. None of that matters. Is it going to matter in criminal prosecutions if people don't realize that they're in a speed limit zone that was all of a sudden lowered and they didn't see the sign, they blinked or they sneezed at that time? Chances are no. So, call to action. What can you guys do? I sure as heck hope you are going to call your legislator, because guess what? The fact that not a single state representative and not a single state senator voted against this tells me that if you are watching this and you live in Michigan, your state senator and your representative are responsible for this garbage. Call them, email them, text message them, show up at their next in-district coffee hours, which they will have advertised on their part of the Michigan Legislature website. Look up your state rep on the legislature website, and it'll show ways to get a hold of them. Get a hold of them in every single one of the ways that are listed. Do it now, do it tomorrow, do it Monday, do it every single day. Tell them they need to fix this, and they need to fix it now. It shouldn't be up to the people to file a lawsuit about this. They need to do their damn job. They need to remember their oath of office. They need to take this seriously. So you call every single one of them. You call the governor's office. She signed this. It became law. You should call and talk to every single staffer you can. It doesn't matter who calls you back. It doesn't matter, because guess what? If they tell you, oh, I can't speak entirely on behalf of the governor or on behalf of Senator so-and-so, you can say, you know what? You don't have to, because state law, MCL 15.151, says that you took that same oath of office to uphold the Constitution. So what are you doing? How can you pass something that is clearly an ex post facto law, that is clearly serving as a bill of attainder, that is clearly not protecting the equal protection rights that we have here in the state of Michigan and, quite frankly, all over the country, violating our due process rights, violating the notions of common sense, where literally even the CDC, let alone organizations like the Mayo Clinic, are saying that COVID-19 has the same symptoms as the flu. It spreads largely the same way as the flu. You are contagious in largely the same duration of time as the flu. It is the same. Okay, so you might lose your ability to smell and taste. Okay. Yep, that's a difference in COVID-19. Are you more likely to have a severe complication out of COVID-19 than the flu? No, actually, the only one that they alluded to or that they stated on the CDC's website as of today is that actually children are far more likely to die or have serious complications from the flu than they are COVID-19. The only thing they said about serious complications where COVID-19 is implicated more than the flu is that very rare side effect from COVID-19, like MICS, I don't remember exactly what it's called. It only affects children, and it's very rare that a child even gets that side effect. Most children don't even get COVID-19. Children are more susceptible to the common cold. Again, I went to the Mayo Clinic, I went to the CDC today to look at this kind of information so that you know this isn't just the attorney who loves the Constitution who's making this crap up. So I hope that this empowers you to hold each and every one of those individuals responsible. Write them an email, send them a text, call them, stop into their in-district hours, stop and see them in Lansing if they're in session Tuesday through Thursday, are their typical days, and you happen to be available to stop in and see them there. Sit in on a session of legislature and tell them it's not okay. Tell them this is unacceptable. If you want to continue to help me fight this fight, I would ask in all seriousness that you help donate to this, because I'm not getting, there's no one obviously paying me. Clearly the lobbyists are not going to pay me. Clearly the legislature is not going to financially back me. I'm here fighting for our freedom because I have children. Someday I will have grandchildren. And I myself want to live in a society where my God-given liberties are respected. It's time that we demand that respect. It's time that we take it back. The power of the people is what really rules this government. Do not be complicit and allow the government to rule us any longer. So you can go to restorefreedomkh.com and donate that way. You can send a check if you would like to do that. The address is on there. Certainly, I would ask that you help circulate our Restore Freedom Initiative petition. That petition is a constitutional amendment that clears up all this. So a law like this would not be in existence with the constitutional amendment that I wrote. The 1976 Emergency Management Act, gone. The 1945 Act that was earlier declared unconstitutional, gone with my constitutional amendment. What about those public health code provisions that the MDHHS director seems to think his orders are in compliance with? Those would be gone too. Every single way that our government has wronged us and is violating our constitutionally protected God-given liberties, all of those laws would be just gone. What about in this instance where we have government officials who are violating their oath of office? Some of you probably feel defeated right now. You probably feel like, holy crap, how are we going to hold the governor, the Secretary of State, the Michigan Department of Health and Human Services Director, the Attorney General, the whole legislature? How can we possibly hold all of these people accountable? Well, with my amendment, if you violate the Constitution, if you are a government official and you violate the Constitution intentionally, such as passing a law that clearly is retroactive and violating our rights against the ex post facto guarantees of the constitutions, you are guilty of a misdemeanor. And that whole, wall of qualified immunity and all that, nope. Enough is enough. No more of that. What about the second time they do this? Because quite frankly, I don't know what other bills they have passed. Somebody told me to look up, I think, 6314. I can only hope it's a good bill. But I'm guessing that if they're passing this kind of garbage, that any of the other bills they've been considering during this time are also just as disgusting and violating of our constitutionally protected God-given freedoms. And so when you have an official with my constitutional amendment petition, this is with the Restore Freedom Constitutional Amendment petition that we've been circulating since the end of May and still are circulating. With that petition, when that goes into place, then when it's a second violation, an intentional violation of the Constitution, that government official is now guilty of a felony. They are immediately removed from office. There would be no need to gather 1.2 million signatures from the people of Michigan through a recall process and then have the governor stay in office all the way until May when the next special election could be held. No, with this constitutional amendment, they would be immediately removed from office once they were found guilty in a court of law of violating intentionally violating the Constitution from a second time. Furthermore, they would be prohibited from ever holding state or local office ever again. You want to join me in a scenario like that where we are fighting for our freedom? Please help me. I can't do this legal work, fight this fight, and then be out on the street getting signatures. I can't be in two places at once. I've done literally hundreds of presentations all around the state, all the way up through the UP, way up on the other side of the Portage Canal UP, all the way down to Detroit and Jackson and Flint and Grand Rapids and Muskegon and Ludington and Freeland and you name it. Lansing several times, Newaygo. I've been all across the state doing these presentations. I'm doing them to educate you on what your rights are, on what the law says, and on what the Constitution says. But I can't fix this alone. And I saw somebody when I first got on here that said, well, we all need to file a class action lawsuit. Class action lawsuits are not the way to go. They're truly not. A lawsuit that has several plaintiffs might be the way to go. But quite frankly, what way would we go with that? Let's think about the complexity here. Do we want to address the issue of masks? Or what about the issue of contact tracing? What about the issue of the temperature checks? What about this law that says you can't even go to work? Are we going to sue the legislature? Are we going to sue the governor? Are we going to sue the attorney general or the secretary of state or the Michigan Department of Health and Human Services director? Who would we sue? What about all the local offices and officials that are imposing this? The police officers that have been out there on the beat writing tickets for violating our Queen's emergency orders? What about the local health departments for issuing their own little orders that are clearly violating the state law they claim gives them the authority and the US and Michigan constitutions? Who would we sue? The lawsuit has to be defined enough that you have a clearly articulable plaintiff and a clearly identifiable defendant or set of defendants. You have to have a clear cause of action. You have to give proper notice and opportunity to be heard. That's the kind of legal system we have. If I'm just kind of throwing it all out there and saying, I'm just going to sue you because you guys suck and you don't know the Constitution, that's not really giving them proper notice and opportunity to be heard. I don't want the lawsuit thrown out before we even begin. So I hope that better explains to you guys why a class action lawsuit is really not the best thing. And quite frankly, any lawsuit is going to need to be really worked out, because look at the lawsuits we've had so far. We started with a doctor's office, 3 doctor's offices, and a patient who sued the governor, the attorney general, and the Michigan Department of Health and Human Services. And where did it get us? Well, first of all, I never even read the full complaint. I only read the state filings that were done in the Michigan Supreme Court. But from what I understand, given the context of the question that was presented from the federal court to the Michigan Supreme Court, the MDHHS orders were never even challenged. October was not the first time the MDHHS director issued those orders. He issued orders all throughout the summer. It was a civil penalty. You had business licensing violations on top of the governor's misdemeanor charges for violating her orders all along. In fact, he added requirements that you had to cooperate with law enforcement when they were trying to enforce these orders. So him issuing these orders is not a new thing. It's been happening this entire time. And they didn't list it. So we have a lot of government agencies and a lot of government officials who are forgetting the constitutional framework from which they get their source of power in the first place, or the God-given liberties that our whole source of government is there to protect. So make sure you're reaching out. Make sure you are making your voice heard before you get shut down on Facebook or Twitter or Instagram or Parler or Wimkin or LinkedIn or any of those, YouTube. Share this video. Share I have a link to the video on my Twitter account, so share that post. I have a link to this video on my LinkedIn, my Twitter and my LinkedIn. Share those posts. a link on my Facebook page, a link, wherever you see the link to this video, share it. Help people understand. Yes, is it a longer video? Absolutely. But I guess you could sit at home and watch 2 hours of TV and miss this video. Or you could stand up and fight for your God-given freedoms while we still have a chance at saving them. If anybody, I know that people complain and want the Cliff Notes version of this. For anybody who would complain about that, about the length of this video, how many hours do you think it took me to put together all this research on this bill, on the constitutional provisions, on the CDC research, or on the Mayo Clinic? I spent hours and hours putting all this together, not getting paid to do it. So needless to say, I'm kind of at my rope, at the end of the rope on my patience level for people that complain that my videos are too long and they want me to boil it down into just a few moments. Okay, so questions. I may try to expedite a case to the United States Supreme Court, but here's the thing. To the person that was asking that, and now it already went, the United States Supreme Court during COVID-19 already struck down a challenge by churches in California who were stopped from gathering for religious services. The California governor said you cannot gather for religious services. These churches said, the heck we can't. We have a God-given, constitutionally protected freedom to do so. They made that challenge, and the United States Supreme Court struck it down and said, no, California can tell you what they want. It's okay. They can do whatever they want to do. I want to say there was also a case that came out of Louisiana as well. I don't remember. There's been some challenging situations, definitely, where our obviously constitutionally protected freedoms are just being tossed out the window by our United States Supreme Court. So it's going to be a challenge. Either way, it's going to be a challenge. Okay, so is Sergey still here? Because I would like to answer his questions. Oh, Barrett. You guys are saying Barrett just by last name, and I'm like, what does Senator Tom Barrett have to do with this? Sorry. Obviously, that's not the Barrett you're talking about. Yes, Barrett is there now, but why don't we see what she's going to do? Why don't we see what, how she'll decide on the first case that she participates in? I'd like to see that before I try to jump right to federal court and handle it that way. Yeah, I see that now, Amy Barrett. Yeah, you don't need deep pockets to donate. I would suggest that if you're only going to donate $1, that you wait till you see me in person, because otherwise the processing fees and all that, I don't know if I'll literally get anything out of that, but you could donate $5, you can donate 10 or 20. I really appreciate that. I have to still buy a new printer. Haven't had the time to research it yet because our legislature keeps pulling garbage like this while I'm trying to figure out the last problem that our government created. But I do need to get some more supplies to be able to fight this fight. Any lawsuits that I will be filing will always have a filing fee. There apparently will be a challenge to the Michigan Open Carry and Michigan Coalition of Responsible Gun Owners lawsuit against the Secretary of State, where the Secretary of State's directive to stop us from open carrying at the polls next Tuesday was set aside. The Secretary of State and the Attorney General said that they plan to keep fighting it in court. So there could potentially then be 2 more levels of court on that. I will have to see what I can do to get involved with that and be able to fight for you guys. Not that the plaintiffs' attorneys are terrible. That's not what I'm saying. I personally know some of the plaintiffs and plaintiffs' attorneys involved, but there's just some of the arguments that I think need to be made that perhaps might not quite be made yet. And I would like to support our freedom in that way. But again, that's going to cost money. Every time I file one of those briefs, I have to file a motion to have my brief accepted, yada, yada. In order for me to figure out what to essentially appeal or filing when the other side appeals. I really need to be able to have the original briefs and filings that were made at the Court of Claims. You can't get those online. You have to pay for every single copy. The last time when the legislature sued the governor, and I wanted to figure out if I was going to get in the stage at that point, it cost $200 for me to get the copies. And by the time that I requested those and the check was given to them, by the time they sent me the copies, there had been an additional set of briefs filed that I then didn't pay for, and I had to go through that all over again if I wanted those. So it's very expensive just to get access to very vital, important government documents. Allendale. Oh, yes, Allendale. Sorry. With the American Patriot Council. I had to remember what I was doing in Allendale on Saturday. Obviously, it wasn't taking a vacation because I need one of those. Any other? Guess what? I do have PayPal. PayPal is set up to, Lori, if you're still on with me, can you comment with the direct Square link for donations? I have Square that doesn't take 30%, takes something like 3%. Square is what's set up for my business. So the legal work that I'm doing here, my business is fronting all those costs. PayPal I have set up to be a distinct thing that you can donate to specifically for the constitutional amendment petition, printing of the petition, advertising. We're doing radio commercials now to try to get people on board and sign these last few weeks that we're doing this. If yard signs, we wanted to pay to get yard signs out to each of the 200 precincts that we're going to be manning throughout the state to get signatures on election day. Quite frankly, if any of you want to help, please sign up at restorefreedomkh.com/election day. If you just go to my main website, there, right on the main page, you can click the very first purple button you see. That will take you to that sign up. We need your help. You might be only able to sign up for 3 or 4 hours. That's fine. Sign up for one shift. Otherwise, please sign up for as long as you're possibly able to do that. If you can talk your neighbor or your friend or your wife or somebody into coming with you, please sign up for both of you there and let me know what your availability is. Let me know which of the precincts that are the best chance at success for these signatures. Please let me know which one of those, or if you're willing to do any of them, check all those boxes. We need your help. I can't do this alone. I can't possibly get 425,000 signatures by myself. And I certainly can't be out collecting signatures every single day when a lot of what's been going on, I've been having to sit here at my desk either doing videos or doing the research to give you guys the information on how to handle this. So please help as much as humanly possible. Yes, if you prefer to send a check to the Hudsonville address, I would greatly appreciate that. You are welcome, Ray. Awesome. Thank you very much for collecting signatures. Do we know if Sergey's still on? All right, guys. I had somebody that asked a question and I held him off for a while. So give me 1 second. I got to see if he is still on with us. Thank you very much for that $50 donation. I appreciate that. Hey, this is Katherine. I'm still doing the live. Are you watching? Because I wanted to answer your question if you're still watching. Okay, I just want to make sure, you donated. I want to make sure I'm very cognizant of your questions, so I'll do that right now. Okay. Yep, bye. All right, so Sergey has been one of our Ottawa County captains. Thank you, Joshua. Sergey has one of been our Ottawa County captains, really, I think from the beginning. And so he's one that did one of these super chat things that I'm still getting used to. And I wanted to respect that, especially if you're paying to ask a question. I want to be able to answer that. Babe, can you tell me exactly what his question was?
If you don't get enough signatures, will you continue to circulate through June of 2022?
Okay, so the question was, if we don't get enough signatures for the constitutional amendment petition that we've been circulating since the end of May, are we going to continue to circulate to get signatures through June of 2022? What the law says is that it's a 180-day rolling timeline. You do have to turn it in at so many days before. I want to say it's 120 days before the election that it would be voted on. At this point, it would be the November 2022 election. So that means you'd be looking at around the 4th of July for a turn-in date. But you don't have that entire time to collect signatures. So it's only 180 days. So let's say I turned in the petitions on July 3rd, 2022. I would only be able to turn in signatures that were no older than 180 days at that point. So that would be roughly January 3rd, 2022. Between then and July 3rd, 2022, that would be the 6 months or 180 days. So if I go beyond Thanksgiving Day at this point, I started May 30th. If I go beyond Thanksgiving Day to collect signatures, then every day beyond that I go, I am then losing that day at the beginning of those signatures. So whether it's going to depend on how close we are. It's going to depend on what's going to take place. If we're so close and we think we can make it, and we can try to energize people and say, hey, we only need 10,000 more. Let's get it done in a week. We could do this. There's 10 million people here in Michigan. I would probably push it out a little bit to make sure that we got that. If we end up being nowhere near, if we don't have the signatures we need, I'm going to leave that up to the people, because I know my team is tired. I'm exhausted, and I have to get into this work right now that's happening in the sense of possible lawsuits or things like that. So, it would really take, it's going to be dependent upon all the scenarios there, Sergey. So I don't know exactly how to answer you other than possibly, but it'd have to always be within that 180 days from start to finish. And it would have to depend on what the people of Michigan really want to do at that point. If we finally have enough people waking up that they're like, oh my gosh, and we go from having 2,000 volunteers across the state to all of a sudden having 5,000 volunteers across the state collecting signatures. Well, okay, then that's going to change things, and we have a much better chance of getting signatures in a shorter amount of time. So it's just going to depend. We have 2,000 people on board, but so hopefully that answered your question, Sergey. Did he end up asking any other questions? Okay, so what is the difference between the pink ones? I don't know what I'm doing here. So Rob, thank you. S. Rivera, thank you. Joshua, thank you. Marla, thank you. Shirley, thank you. I don't see any additional questions with those. Yeah, so basically, if you guys are collecting signatures for me, it's not complicated. Any person can do it as long as you're over 18 years of age and a U.S. citizen. You don't even have to be registered to vote to collect signatures here in the state of Michigan. So as long as you're collecting our signatures, there's a 12, 13-minute training video that we have that helps make sure that you know all the different. You are welcome, Sergey, and thank you. I'm praying too that we have enough. Absolutely, we will change the world if we get this amendment into the Michigan Constitution. Absolutely. So guess what? You can sign. That's an interesting YouTube name, because then people think I'm asking guess what. Anyway, you can sign in a lot of places in Macomb County. If you go to restorefreedomkh.com, there's literally a tab that says where where to sign, I think is what it says, or where can I sign? Click that. You'll be able to see it in terms of signing events that are specific, like one-time things. You'll also be able to see a list of signing locations that are in businesses and homes all across the state, or in your case, a particular county. And then Lori just gave you that link. But really, guys, it doesn't take a lot. I have people that have never been politically involved. I have people that are in their 80s and 90s out collecting signatures. I have people that are just 18 years of age, and they're still in high school, but they're out collecting signatures. Guys, we could do this. We, the people, can stand together and get all these signatures. We just need to work together on it. So it can happen. It's honestly the best way to fix all this. Even if we don't get the signatures, I'm not going to stop fighting. Restore Freedom with Katherine Henry will definitely continue to cause problems for those government officials who keep violating our state and federal constitutions. So I still want you to be on the team, so to speak. Lori, I don't know if you have the link, but can you post the link to our sign-up sheet for, let's see if I can do that real quick. So in the event that, Facebook is starting to smack us all down and not let us cooperate, or, not let us do things, how do I share this? That's pretty sad. Okay, there we go. If you guys can fill out the Google form that I have right here that I just posted, thank you, Lynn. What that Google form will do is allow you to sign up to continue to get updates and things. If Facebook shuts us down and Twitter shuts us down, and even if YouTube shuts us down, it'll help us be able to stay in touch with you. So please help to spread the word. If you can, copy and paste those links. Share that Google form link, which is essentially I'm calling it a newsletter sign up. I'm not intending to necessarily do newsletters on top of all the videos and all the other things I'm doing at this point in time. It's like a backup newsletter. And if you can help to share those election day signups so that people can sign up for even just one shift would help us immensely. Again, restorefreedomkh.com/election day, or the Google form to sign up for the backup newsletter is on there. Again, thank you so much, guys. I really appreciate it. Not 1.7 million signatures. Recall Whitmer needs just shy of 1.2 million, about 1.16 million, I believe, signatures in a 60-day time frame. We need at Restore Freedom 425,059 signatures in order to get it on the ballot. So as far as donating where I don't get charged, that's a hard one because almost every place is going to charge. If you sent a check, that would be a way that you can donate where there's no charges that come out of that at all. Otherwise, if you want to do it electronically, everybody takes their cut. I understand that it's business. Square is going to directly fund all the legal work efforts, like this video and doing all the research and printing all the cases and the statutes and the constitutional provisions and things like that. Square only takes roughly 3%. So it's really one of the lower ones out there, and it's hassle-free. I mean, really it is. I've had Square for 12 years or so. So I just want to make sure if there's any last questions. Okay, so it sounds like they are. Why did it only take about 2 weeks to get a court decision on open carry at the polls, but the MDHHS orders are still in effect? Because no one has legally challenged the MDHHS orders. That's quite frankly the answer to that. As far as getting an answer about the polls, Michigan law, and it might even be in the Constitution, says that anything where there's a lawsuit specifically challenging an upcoming election has to be fast-tracked, because they want to make sure that election rights are preserved and the election integrity is maintained. So anything with an election does get fast-tracked, but keep in mind, the decision that came from that court, that's just the trial level. We still have the Court of Appeals that is coming it will be involved because the Secretary of State and AG are going to appeal. and then it might end up going to the Michigan Supreme Court. So, and if I were them, and if I lost with the state Supreme Court, I would be filing at the United States Supreme Court. So, hopefully that answers those questions. Quite honestly, I just don't know that I could do any other kinds of apps. I mean, my life is full of technology that, quite frankly, backfires a lot of the time. Our PayPal, which is, or excuse me, our GoFundMe, which is set up to help fund our personal, like so I can continue paying my mortgage or continue to pay for the electric bill and things like that. That started giving us problems about a week or so ago, where it disconnected us from everything, wouldn't deposit the funds. It was a great time. So I just don't know if I'm really up for. I'm already using Square and PayPal and GoFundMe for the different sides to this effort here. So I might look into other ones at some point, but I just can't do it right now. Okay. Okay, so it looks like Jeff, no, they cannot utilize elements of contact tracing. Not at all. We have in Article 1, Section 11, right in our state constitution against unreasonable searches and seizures. And this is where the government is forcing private entities to collect all of your private information and then turn it over to the health department. Also, we have the same right under the Fourth Amendment to the United States Constitution. They don't have a right to do that. I'm not going to give them my information. I certainly hope that you will not as well. Okay. Okay, so one last question here. The signature goal, our signature goal is actually only 450,000 because with our instruction video, with the thousands that we've been validating, our error rate is much lower. So we have already validated around 35,000 signatures from every single county across the state. So we have signatures from all 83 counties. We have validated signatures in each of those 83 counties. We validated more signatures in Wayne County, for example, or Kent County than we did in Gogebic County or Houghton County. But we are validating signatures very strategically in a much more stringent fashion than the Secretary of State themselves will be doing to try to trip us up or see if we don't have appropriate signatures. So in the end, our signature goal then does not have to be as high. Whereas Stand Up Michigan, when they were doing the Repeal 45, my understanding based on their videos was that they were just doing sampling 500 here and then 500 here. And total, they might have had 1,500 or I don't know, signatures total that they verified. Whereas we literally have already verified over 35,000 signatures, and we're not stopping. We're going to strategically finish our plan to make sure we are validating signatures appropriately by a percentage in every single county, and a higher percentage in those counties that are known to have more voter registration issues. So we're going to do this the right way, definitely. So, well, as far as running for office, Stephanie, first of all, thank you for the donation. I am running for office. I am actually listed as the one of the Republican nominees for Georgetown Township trustee in the west side of Michigan in Ottawa County. So if you live in Georgetown Township, please make sure to come out and vote for me on November 3rd. And if you don't live here, you can't vote for me, but you can certainly support me in other ways. I did that because someone asked me to do that because we didn't have enough people stepping up to stop our local government from trampling our freedoms and wasting our money and those kinds of things. So that's going to be fun. You might want to stop by the first night I get sworn in and bring some popcorn. It's going to be a good show. And you don't have to wear a mask because I will be upholding our God-given constitutionally protected freedoms because that is my duty to do so. I took an oath of office after all. Thank you, Chad and Jill. Thank you, Adam. If I can get anybody to register to vote, that's a good sign. All right, so guys, I'm going to go make sure that my family can have some dinner now, and I have to reassess and see what other kinds of crud the government has been getting into. But I do appreciate every single one of you for being on board here and for donating, for asking all the questions, for paying attention to what it is that we're trying to do here. I really do appreciate that. And again, thank you so much. And I look forward to the next time I get to talk to you all. Have a wonderful night, everyone.